I'm pleased to introduce Colonel John Daly. Before attending law school, John was a Top Gun fighter pilot in the Marine Corps for 6 years. The Marines then sent him to Creighton Law School, where he was editor-in-chief of the Creighton Law Review, and he graduated summa cum laude. After serving as judge advocate in the Marine Corps, John joined the law firm of Skadden Arps, Slate, Meagher, and Flom. And in 1995, he became a Fitzgerald lawyer and has been the managing attorney of our appeals department since then. John, we've introduced the Fitzgerald trial lawyers and the Fitzgerald litigation attorneys and some of the honors they've won and records they've set. I'd like to talk to you about records the Fitzgerald appeal lawyers have set on cases by children for medical malpractice against New York City-owned hospitals. In order to sue a New York City-owned hospital, when must a notice of claim be filed?
Within 90 days of discharge from the hospital, unless there is continuous treatment. It is a ridiculously difficult requirement. Let's say the child has suffered a birth injury but is discharged in 3 days or a week. The mother may not know the child has a permanent injury for months or even years. Very often the mothers are told, "Don't worry, he's just a little slow. He'll catch up." Against any other hospital, the child would have 10 years to sue with no notice of claim requirement.
But there's a procedure in which we can apply to file a late notice of claim.
Yes, but it's a tough standard because we have to show that the city hospital had actual notice that the child had been injured by malpractice. And the hospital takes the position, "Gee, we thought the child was okay."
But the Fitzgerald lawyers take these cases.
Yes, most other law firms wouldn't touch them.
How do you win them?
First, by spending a lot of money on expert medical witnesses to demonstrate that the hospital had actual notice of both malpractice and injury. Then there's the issue of, why did the mother wait so long to seek an attorney?
Are the decisions appealed?
Absolutely. New York City almost always appeals when we win. That's why other law firms are reluctant to take these cases. And we appeal when we lose.
Tell us why the Fitzgerald lawyers take these cases.
Because we don't think a child should be out of court because he didn't make sure his mother filed a claim by his 3rd month's birthday.
But let's talk records. How many of these birth injury cases against New York City hospitals with late notice have the Fitzgerald lawyers filed?
I would estimate over 200 in my tenure.
What percentage of these late claims against New York City hospitals have the Fitzgerald lawyers filed?
John, based on the reported cases, I would estimate that it is as many as all other law firms combined. If not 50%, very close to it.
And what percentage has the Fitzgerald Appeals Department won?
John, let me put it this way. If the court accepts that our medical experts have demonstrated that the hospital had actual knowledge of the malpractice and injury, we don't lose. We have never lost solely because of the mother's lack of an excuse.
And this has resulted in settlements and verdicts for children with disabilities?
John, untold millions of dollars for children with disabilities.